Your Honor, we have a hearing in the matter of CFI 041/2017 Amlak Finance, PJSC versus Mr. Nigel, Anthony John Herbert, and Mrs. Deborah Jane Reeves in the matter of CFI 041/2017. Claimant is represented by Nicholas Braganza by Clavicle LLP, ex parte.
All right.
Thank you, Your Honor.
First of all, just I want to know why I'm getting late submission in the authority bundle.
So there were just a number of additional authorities we thought it would be useful for the court to have.
My question was late. I received the authority bundle yesterday afternoon, and I'm receiving this 10 minutes before this hearing.
No, sure.
So what is the reason behind that, so I can assess whether I accept it or reject it?
There are a number of authorities that became apparent yesterday, and we thought it would be helpful for the court, and they are just the rules of the DIFC court, which of course you have to hand.
3 days before the hearing.
Sorry?
The rules of the DIFC court to have the submission 3 days before the hearing.
Yes, no, and we apologise for that. No,
I just want to know the reason.
Yeah, the reason is that
it's a judgment of DIFC court, another judgment probably. So, but why it's already there, so you can print it and file it with the application bundle.
Yes, no, absolutely, and for that we apologise. There is no excuse
for your skeleton argument. You made some reference to the Mann case.
Yes.
But have you now making a...
That is already in the legal authorities bundle.
Yes.
Yes.
For the additional authority cases...
they are not referred to in the skeleton version.
Okay. Just I want to make a reference to that.
Sure.
Go ahead.
Thank you very much, Your Honour, for agreeing for me to make representations to you. I'm only Part 1 registered, but so thank you. So in this reference, we are representing the claimant, Amlak Finance PJSC. These are enforcement proceedings, and so today we're asking the court to exercise its powers under the rules of the DIFC courts 2624. The court may, upon a claim by a person who has obtained a charging order over an interest in a property, order the sale of that property to enforce the charging order. The Part 8 claim followed. So the final charging order was issued by the court on the 11th of July. The Part 8 claim was filed on the 13th of September 2017. You have that at tab 21 of your hearing bundle. Service was effected on the 9th of November. As the court will be aware, the defendants are based in New Zealand, so we sought the permission of the court to waive the requirement for service by diplomatic channels. That was ordered by the court pursuant to 2 orders. The order of Judicial Officer Nasser al-Nasser, dated the 20th of September. This order stated that service could be made through alternative means, but if the defendant did not acknowledge service, then the claimant would have to serve through diplomatic channels. So the proceedings were served by email. They were also served by courier, as stipulated in the order of Judicial Officer Nasser. The processor, we also arranged for a process server to serve the proceedings on the defendants in New Zealand. The process server found out that the defendants had moved house, and so we served the proceedings on the new address as well. We have certificates of service for both addresses. They are in the bundle if you'd like me to take you to them.
Yeah, this is I want to take you. If you can take me.
Yeah, of course. The order of Judicial Officer Nasser al-Nasser is at tab 25 of your bundle.
this is to leave the document in the last known premises.
Correct. And so, yeah, that's C123. The claimant is to serve the defendants at paragraph 2, located outside the UAE, by the following methods. So we serve them by email, we serve them by courier, and leaving a copy at the address. That can be found in the exhibit to the witness statement at tab 29. So the proceedings were served by email. That's C141, tab 29. So that was sent to 66kips@gmail.
Now, what about the new address?
Yeah, so that's the email. The following page is a confirmation of the email. So then if I take you to the proceedings were served by DHL, that's C143, and that's the address stipulated, which is the Joyce Road address. And then if I can take you to page C146.
146.
So you can see the name of the process serving agent is Mike Gillen. He said, agent attended this morning and spoke with the new tenants, occupants of the property. They provided a new address in Taranga for the respondents. Would you like us to leave a copy? So we did that. And if I can turn you back to C144. So that's the service report. C144 under tab 29. At 11:35 on Thursday the 9th of November, they served on 282 Joyce Road, and then at 12 o'clock they left the same at the new address as informed to the process service agent, 1004 Ohawiti Road, Taranga.
Okay, there's no any further points for me for the service. Dean service been done,
So thank you.
Back,
Thank you. Under pursuant to 957 of the rules of the DFC courts, the defendants had 28 days from the date of service, which was deemed to be the 9th of November, to file an acknowledgement of service. No acknowledgement of service has been served. No other communication has been received from the defendants. Part 8 doesn't permit default judgment, so the court has directed the hearing for today. And at this hearing today, we ask you to exercise the court's powers to order the sale of the property.
Yeah.
In terms of
We're dealing with part 46, right?
yeah, so part 46 of the rules of the DRC court.
We need to discuss more about the cabinet form and all of this.
Sure. Okay, so we're at part 4624.
Yes.
So that's your power. 4625, the claimant must use the part 8 procedure. A copy, part 4626, a copy of the charging order must be filed with the claim form. That's been satisfied. 4627, written evidence in support of the claim must be filed. So if I can take you to the witness statement in my name, which is at tab 22, C3.
Yes.
So we need to identify the charging order, under subparagraph 1 and the property is sought to be sold. The charging order is at C4 of my witness statement, identified as the final charging order of His Excellency Judge Omar Maheri, dated the 11th of July. The property is also identified there, so it's Unit N2003 of Emirates Financial Tower, located in the Dubai International Financial Centre. The amount under subparagraph 2 must state the amount in respect of which the charge was imposed and the amount due. So at that time, the amount due was US dollars 1,176,102. That's the judgment debt, and that's identified also in that subparagraph 3.1.
Yes.
Under subparagraph 3, the debtor's title to the property charged. So this is a difficult question.
This is the main thing.
Yeah.
We are satisfied with all the requirements for
Yes.
46.47. The only things we need to discuss more in detail is verify the debitor's title to the property charge.
Sure. In terms of there is no title deed over the property. Until it is transferred, it was constructed by Emirates Financial Tower and handed over because of the nature of the financing over the agreement of the property. It was an Islamic financing, which a murabaha, whereby it was a lease and sale back. So the property was registered in the name of Amlak, PJSC, and then Mr. Herbert and Mrs. Reed would have possession, and they would pay back that loan over the period of X number of years under the terms of that leasehold agreement. And at the end of that leasehold agreement, it would then be transferred over to Mr. and Mrs. Herbert once they'd repaid their finance over the property.
Now, did the Amlak finance the whole amount, or
Yes.
just part of that amount?
Yes. There's some lesser a deposit that was paid by Mr. Herbert originally over the property. In terms of that. I've got to pick that figure.
I'm looking to the caveat form, and I'm looking to the PJSC Real Property Law, Part 17. So maybe you want to take me to those documents.
Yeah. So in terms of the offer was made in 2007. The loan advance was 2.9 million dirhams. So actually, at the time of that the financing was given, no registration was made by Amlak. As I said, no title deed had been issued at that time. The caveat form, which is at C29 under tab 23, was filed by our client Amlak on behalf of Mr. Herbert. C23?
I have just two questions before we...
Yeah, C29, sorry, yes.
Before we move on. Now the defendant, how much they pay to the Amlak in total? So how much that represents in percentage from the finance amount? The mortgage? The purchase price was 4.9718201. This I'm reading from the cabinet.
Yeah.
So I want to know the defendant, have they paid any payment?
Yeah, they issued, if I can take you to C19, which actually sets out the payments that the first C19, yes, this is in the, it's from the particulars of claim actually, it's elsewhere in the bundle as well.
Yes, 149?
Yeah. So yeah, 149. So as security for the check for the rent payments, the first and second defendants were to provide 40 post-dated checks in favour of the claimant for 149,569.
So you received that?
So I received those checks, but as I understand,
Cashed or rejected?
they were rejected. They were bounced for insufficient funds in 2012.
So received zero?
They paid administrative fees totaling 21,570
To Amlak or
to Amlak, yes.
And the administrative fees is not part of the purchase?
No, it's not part of the purchase price. No other payments have been made to the claimant by the first and second defendants.
So the defendants, in your report, have not paid anything from the purchase price, the original price?
No.
Okay. So there's no payment at all. And just to help me to understand the fact, the defendant, they enter that premises, they live in it? Or?
No, never. I think it was the agreement was signed before the property was ready to hand over.
Right.
The handover happened, I think it's in the bundle actually, at
So property now is empty?
the property now is empty.
Yeah.
It's not. It's in the possession of Amlak Finance. It's always been in the possession of Amlak Finance.
On possession mean you have the keys?
Possession, we have the keys. Yes.
And the property, I mean the registrar, they give the key or
The handover happened. It's at tab 35. Happened on the December the 28th, 2011.
The handover from the developer? Or?
From the developer, yes.
What is that tab?
Tab
35?
35. Yeah. So that confirmed that the developer was satisfied that all payments were paid and no objection to handing over.
But they hand over to the defendant, right? Or they hand over to you?
At that stage, Mr. and Mrs. Herbert were not in the United Arab Emirates. Although this states as it was supposed to be the handover to those, but in practice, practically speaking, it was handed over to Amlak Finance.
But this certificate did not mention Amlak at any point, right? The certificate of payment and objection of the handover has nothing to do with Amlak. In words, there is no Amlak reference was made to the certificate, right? And the receipt. As far as I see. So it's basically handover from developer to the purchaser, right?
That's what it states, yes, but in practice it was handed over to Amlak.
And how did this come to your position? You asked for it or as an Amlak?
Yes, well, when they took possession of the keys to the property. they issued this certificate to confirm that all payments had been made to the developer and there was nothing more outstanding.
And whether or not this paper is already in the real property registrar folio, the custody of the registrar of property as well.
Yes, I assume so.
Okay. If we can move to the caveat form, which is
Yes. C29.
Now, this form has been filled by Amlak and the purchaser, or just Amlak, or
It was filed by Amlak on its own.
no, who filled
It was signed by Amlak.
only Amlak,
Yes,
not the purchaser.
not the purchaser.
Now, this caveat form has been, whether or not has been registered or by the real property registrar, or
Yes, it has. It has been registered. It has been registered with the registrar of real property. If you go back to C27, you'll see this was
C27.
C27. As you see, this is some years later, and Amlak thought it appropriate to register this interest at the invitation of the DRC registrar. So it then sent this form.
Now, my point, where is the seal or any letter from the company, from the real estate registrar acknowledging this caveat form? Because when I look to the real estate property law, I'm reading from the the part 17 caveats and DRC real property law. Seems to me it has to be recorded in the registrar folio of the registrar. So does this caveat recorded?
I've discussed this very subject with the registrar.
They couldn't record it because there is no transfer of ownership from the developer to the
Correct.
mortgagor or to the right.
And more fundamentally, there's no title deed over the property.
So if the caveat was not recorded, then how we can remove the what they call it here, the caveat, the caveat.
Yeah. In terms of that, I understand. But that caveat is registered with the registrar of real property.
When you say registered, mean just give me more details. How that registered without obtaining any registration seal from the real estate registrar or any acknowledgement of registration? I can understand. I see your letter, Amlak letter to the registrar of DRC property attached with the caveat form, but I don't see any acknowledgement or any registration number, whatever, from the real estate registrar. Just correct me if I'm wrong.
No, you're correct. You're correct.
I see your point. You say you deem it being registered because you sent that letterhead with that form.
And the registrar will not confirm that the caveat is cancelled without an order of this court.
Yeah, this is second stage.
Yeah.
The first stage, the first question we need to clarify whether this caveat actually, if there is a caveat or not, because the caveat has to be registered with the real estate registrar to give it that effect. And maybe if you look to 116, do you have the real estate property law?
I don't have that with me, no, sorry. We can.
It's read as this, a caveat. I'm reading from 116, chapter 1 in part 17, caveats. This is GIFC Real Property Law number 4, 2007.
Yes.
then amended by DIC law number 4, 2012, a caveat may be lodged in relation to real property or a registered interest in the real property, such as registered lease or a registered mortgage, by any of the following persons of their agents. Now, there is a person claiming an interest, which is probably the defendant here, right? Then B, the registered freehold owner of the real property. Now the question, another one of those questions, whether or not Amlak is a registered freehold owner for this property. In order to give effect to a caveat being issued by the registered, by Amlak itself, not by the registrar. So there is two ways to deal with the caveat. Either this is being is being registered by a separate entity rather than the registrar of the real estate. And if that happens, then the freehold owner has to be registered with the real property. So the freehold owner here, Amlak, has to register that interest with the real estate registrar, if you follow me.
So it needs to register its freehold interest over the property with the registrar.
Which has never happened.
Which has never happened because there's never been a title deed.
Exactly.
It can't issue its interest against a property which doesn't have a title deed.
And the title deed was not transferred, if you like, from the developer to a purchaser or to Amlak, because do you have any background? I mean, there is any information why that wasn't happened?
I think it's part of a wider property, and in order to, once it was going to be transferred on, it was supposed to be transferred on to the defendants, but because they were never participating, they never took any role or showed any interest, we couldn't contact them to transfer the title deed. Once we needed to transfer it to them.
Wasn't there any communication between Amlak and the developer and see why they didn't transfer the title?
Yes, and we ourselves have transferred that, and they say that they aren't able to issue any confirmation or issue the title deed. And then we went to the quite recently, and then we also went to the registrar and said, please could you
yeah. Now we're talking about the same building, the Emirates Financial Tower.
Yes.
From your information, or
yes.
just want to understand the facts here. Did developers transfer the title deed for another purchaser or to Amlak in another case, or because I want to know if this is an issue of the tower itself, so that the building itself ownership was not transferred, or just for you, in this case, for those defendants.
I don't have instructions on that. It's my understanding that it's those units that Amlak possesses.
But it could be.
But it could be. Yeah.
It could be for the full building.
Yeah.
They didn't transfer the ownership.
I don't have instructions on that. I don't know.
Now we have a tough situation here where I need to go through your application and give you that order to be satisfied with 46.273, verifying the title to the property. Now, I see in your skeleton argument you say that in 4.8.5, while the claimant owns the property, there is no title deed issue in the name of the property.
Yes.
Now, I should stop in this first sentence because on paper, still, I mean, the Amlak is not the owner of the property.
On paper.
On paper, because there is no title deed for Amlak, first of all. It seems to me, from the face of it, still the developer is the owner of those units, because unless, as well, they don't have a title deed themselves. But
I think that's the case.
Physically, let's say, once it's within that building, it's the building owned by the financial. I mean, I don't know who the developer. This is the name of the building.
Towers.
I don't know who the owner of the Emirates Financial Tower. It's not in the record here. Unless I'm missing something.
Yes, just Emirates Financial Towers Limited.
Yeah. So this is the name building and the developer name as well, right?
Yes.
Emirates Financial Tower. Now, I've seen the data issued to the your client to the Amlak from the registrar of the real estate, which basically is saying the same things. They cannot transfer or they cannot issue a title deed because the ownership wasn't transferred from the developer. And this is something you might want to consider going forward to see how you can address this issue towards the Emirates Financial Tower. See, this is, we are dealing with a situation where probably different than other cases.
Oh, absolutely.
The Shamlan case where there is already a title.
Yeah.
We have a problem here that the defendant don't have a title, and the caveat even is not registered with the real estate authority. And I'm dealing with two difficulties here. First, how I can remove something which is not in first place registered. So how can I remove the caveat and cancel the caveatee from that interest, where that caveat seems to me is not registered with the real estate property, real estate registrar.
Well, actually, today I'm not asking you to cancel that caveat. I think we've asked
we
you.
need to cancel it in order to give you an order to sell the unit.
Yes.
It's a one unit, right? Not two units.
Yes, but if you're saying that you're not satisfied that the caveat is registered or even exists, because
There's two things. This is what I'm saying. I'm
If-
not satisfied about that caveat is exists because I don't have anything
Okay.
record from the registrar. Second, the big issue, the title, because the requirement here to verify the debtor's title, and there is no title.
yes, there's no title.
Probably this is something you will need to take it with you and think about how you can approach this situation, this case in different way. That maybe the defendant not the right person to bring in this case or this situation. Maybe you want to think about who's the current owner of those property and try to take an action or something.
So we've been through this process, as you'll appreciate. This has been going on for some years, and
I want to solve that.
and we're looking to the court to help us to solve it. There is a problem that we don't have a title. There's a problem that the developer is not confirming one way or the other who is the owner. It doesn't have a title deed. That's been confirmed to us. I met with the registrar on the 21st of January to ask whether there has been a title deed over this property, and he said there is no title deed over this unit. So the situation is there is no title deed. We're in possession of this unit, and now we're asking the only way to get back, is to sell it.
Why do you want to go to that road? I mean, just I'm thinking now.
Yeah.
Maybe more than legal, it's more than business. I mean, the Amlak to get back the mortgage amount, they can at least lease that unit instead of selling the unit, so I get back some cash or like alternative.
Yeah, so that would be an alternative for them to do.
You know what the problem? How are you going to enforce my order? Even if I give you an order to sell the unit and you find a purchaser.
Yeah.
How the purchaser will get the title? He wouldn't be able to do that because the unit itself doesn't have a title in the first place. So the new purchaser will have the same situation. You know what I mean?
I understand.
So if I give you an order to sell it, you will not be able to sell it because there is no how the new purchaser will register his interest in this. See, he wouldn't be an owner of the unit, and that will be a problem for you to find a buyer to convince him to buy the unit.
Can I ask you, the court, to make an order to the DIC registrar to issue that title deed?
Well, this is another situation again. I mean, this is
because that was something that we did ask for in our original relief, which was in the related proceedings CFI 2010 of CFI 10 of 2015, we asked for the court to order that the DRC registrar, they were party to those proceedings, to issue the title deed. And then once we have the title deed, we can establish, then we can transfer it on or establish the actual status of it.
The problem with that is definitely it's administrative fees or administrative requirements. So how the court will get interfere in this while the registrar of the real estate, they have a requirement to issue a title deed. As they said in the letter, the owner, the developer didn't transfer the ownership to them, so they can then transfer it to the new purchaser. So the main point, I guess, is to deal with the developer, the current owner on paper. So Emirates Tower, Emirates Financial Tower probably need to be put into the picture. I don't want to give more details on this.
No, sure. Can't
So,
advise.
I think this is the main thing. So, because it seems to me right now they are the entity who are not facilitating the, let's say, the arrangement, or not facilitating the whole process of getting a title deed. So to get an order for sale without having a title deed on those defendants, and this unit for the defendant will be a problem for me. It seems to me there is no way to go with this, because very obvious that the defendant on paper they pay for the unit, but they don't have an ownership on the unit.
Yes.
So how I will be given order to sell this for their debits if they don't have the ownership?
So what we are asking...
They don't have that ownership certificate.
And they have an equitable interest in the property, and that's what I'm asking. That we are asking you to issue the order for sale against that interest in the unit, rather than their legal title to the unit.
Again, we go back to the 47.27. We have to verify the title. See, the problem is there is no requirement for title for the property. You're dealing with the property is a very sensitive subject.
Of course.
You cannot get in this without make sure 100% this assets belong to the defendant, the debtors. So I think this is something need to be dealt with between you and the current owner on paper, which is Emirates Tower, Emirates Financial Tower, or bring them the third party in the enforcement process. See how it works, because this is an alternative. Then it will be a DIC enforcement judge who should deal with this as enforcement matter, not as a claim.
Well, this is enforcement proceedings. Yeah.
No, this is CFI claim because Part 8.
Yes.
And that's what I confused in the first place.
Yeah, sure. So it's but 4627 says we need to.
Yeah, it's 46 is a new Part 8 claim, because you are asking, to sell property for the charging order. This is why we went through all of this. But maybe if you give it a second thought, it would be more maybe useful for you to consider to submit a new application in enforcement file and bring the third party to this situation.
But we have a final charging order over the property.
Yes, I understand.
So the next stage is to ask for an order to sell. But I understand that the conditions are not satisfied for you to order sale, so we need to go back and to enforcement.
Yes, and want to enforce your. You want to file an application for the judgment creditor to enforce their interest in the third party, on the third party. Who's now the third party is Emirates Financial Company. And seek an order from the court to support in this depends on your remedy. I cannot give you more details what remedy you want to ask. But this is, seems to me, this is the exit way from this. Because the Emirates Financial Tower, they cause the judgment creditor currently a problem for put hands on the, not just the physical property, but to go through the selling the procedures, because there is no title. And whose fault for not transferring the title as the registrar, or say the owner, the developer, they didn't transfer the title. So all the requirements are satisfied in terms of the cash payment, everything, but transferring the ownership, this might be a request from judgment creditor to the court to ask a third party to transfer the ownership.
I see.
So when the ownership transferred, it will be no problem for maybe different cases or different situations.
And in that situation, there is no need to be concerned about the defendants in that case, because actually they have no interest. The property is in our name.
Exactly.
We believe legally, but it's not legal until it's registered.
Now, it could be the second stage to come back to the court for sale, but the first stage is to ask or to issue an order from the IC court, an enforcement process, asking the Emirates Tower to transfer the ownership of the judgment debitor.
Yes.
So the registrar will be able to issue a title deed in their name, then you will get it afterwards. They will not issue it directly in your name, because you need only the finance, not the purchaser. So they will issue it under the purchaser name. Now, in that situation, it might be a little problem where maybe the real estate registrar will ask for the fee.
Sure.
For the purchaser and order. Then you have to deal with it and see how you can solve it as part of your loss. So this is, I guess, the way how you can think about it. But currently, it will be for the DIFC court not appropriate to issue this order without having a title deed.
No,
I hope you understand.
No, and we thank the court. We've been in this situation for a number of years, and in terms of nobody is able to find an answer.
Once you read the letter from the registrar of real estate, you will see where the problem and how you can approach that problem. And
we did this, and we didn't get anything from them.
Well, then
so
you
then
need to come to the court and
we
ask.
need to come to the court and ask.
Because defendants, they cannot help you right now. Their situation is not helpful anyway. In terms of that.
I mean, they've clearly wiped their hands of this. The defendants.
And that will help you even for sale. That will help you just to get an order from the court. I mean,
of course.
For forcing the financial tower to transfer the ownership, but for selling the unit afterwards, because then you will go clean title deed to the new purchaser and say, look, this is the unit, it's already been, all the issues been clean, there is a title deed on this unit, and then the price maybe goes up better than now, where you're going to sell it without a title, then the purchaser will hesitate. He say, look, why I should get myself in this and because you want to get back your money as Amlak. So the best way for you is to sell it in high price, and the only way you can do that is if it is a clean unit.
Yes.
I mean, there is a title of it. So you mix the business side of it and the legal strategy as well.
Thank you. We thank the court.
Clear, right?
We thank the court for its assistance on this matter, and it is a difficult matter because of this issue with the title deed. We appreciate, and we thank the court for its guidance.
I see the situation Amlak been through, and I cannot blame Amlak for financing a project which is not that much clear whether whether the ownership will be transferred or not. But this is a business decision has been made that time. And this is the risk, always the business people they take when they take a decision to finance a project. But I think already the Emirates Financial Tower already exists there, and the developer should have no problem for fulfill their obligation to transfer the ownership to the real estate registrar, and the real estate registrar will have no problem as long as the purchase price already been made. So just we need to pick the right person, the right party to ask him to do the right things. And this situation is not helpful right now. I told you it might be just a slight difficulty when the real estate registrar were going to issue a title deed for the purchaser, the defendant. He might ask for fees for that. Then the Amlak have to sit down and think how they can solve that problem and claim back this amount and deduct it from the selling price afterwards. So I think this is the strategy, if you like.
Thank you.
Currently, I apologize, I cannot help you with your application because all of us, two of us, will see the difficulty of doing this.
Yes, no, we understand.
So I will, issue my order to reject your application on the current situation and with some reason.
Yes.
And then you will take it from there and see what you can do in enforcement.
Good. Okay.
Enforcement process.
Well, thank you, and thank you to the court
Now,
for listening.
if you want to say anything more, or
No, that is clear, and we thank, as I say, we thank the court for its assistance.
Yeah, my pleasure. But even as I told you, I don't know. I mean, most Amlak need to think about all the caveat form they have, why they didn't get recognition or certificate from the real estate registrar. Because in there may be regulation, I'm not full aware of their regulation, maybe they cannot, what the word is, register, record that caveat because the developer is not paying some administrative fees or something. So this is the only reason I'm thinking why you didn't get, maybe you sent that letter but you didn't follow, the client, Amlak didn't follow with that letter. Why there is no letter from...
I think they had communications with the registrar and they said they were unable to issue that.
At least to, I'm not saying to issue a title, I'm just saying to issue a recording certificate of the caveat form. You know what I mean?
Yeah.
Yeah, this is the area where maybe for the interest of Amlak, maybe thinking again now to do something about it or to ask the registrar why we don't get a certificate to record our caveat form. Because it seems to me from the real estate law, real property law, there is a need to record that type of, and it makes sense, from legal side. So that caveat needs to be recorded and registered with the real estate registrar to take effect, because there is some articles, if the that caveat need to be removed or something, there should be like a and even after the recording, the registrar of real estate has to notify all the party mentioned in this caveat about the recording. So there is an article about recording that caveat form. But even if we're not considering this as a main problem, we have another problem with the title. But this is just for you to go back to your client and check behind that situation whether or not your client Amlak need to get some confirmation from real estate registrar about all the units they finance, whether or not the caveat form has been recorded or not within the folio, because the folio of the registrar.
Yes.
Well, so this is the end of it, and thank you for your attendance.
No,
and,
thank you.
I hope
Thank you.
it was
No, it was very
I hope it
helpful.
was useful.
Thank you. Thank you
All
very
right,
much.
thank you. Appreciate it. Have a good day.
All rise.
Thank you.
very much. Are you one of the new case progression officers? What's your name? Hi, I'm Nick. I have lots of dealings with the registry. So,
I started before.
you started from?
February.
Okay.
Yeah.
Registered so.
Yeah. Yeah. 18 years ago.
Good. So you are the new Lima.
Yeah, probably. But let's just stick to my name. It's not good.
Thank you.
Thank you. Have a good one.
So actually, he's right. There's no need to care about.
Please keep it easy.
Music. What we need to do is get comfortable. Thank you for the. Yeah, just thank you so much. It's like a lesson.